All right. Is Ms. Green present? Or?
No, Your Honor, she has pneumonia.
Okay. All right. Where are we on this one, folks?
Termination of tenancy, month to month, proper notice from section 8, they're terminating due to the tenant's actions, asking for a possession judgment, Your Honor.
Your Honor, I was handed a termination notice a few minutes ago dated December 1st, 2023, saying that due to program violation by tenant that the contract would be terminated on December 31st. I think this was issued in error because we have not received a final decision on the ALJ hearing that I conducted. And then I looked at the letter that was provided to me by plaintiff, and the HAP contract did pay in January. And then I was on the phone with CMA.
Hold on a second. Your notice, a 30-day notice?
It says contract termination notice, Your Honor, but I think.
Well, what is it from? Who's it from?
It's from MISHDA, Housing Choice Voucher Program.
Okay.
It says that it was terminated due to a program violation by the tenant, but that flies in the face of conversations that I had with MISHDA and CMA yesterday. And also it flies in the face of the fact that the HAP contract paid January's rent. So I think this was issued in error somehow, and I want to investigate it.
Yeah, but hold on. Where'd you receive that from? You
From plaintiff's counsel, just handed it to me.
So plaintiff's counsel received that from MISHDA, and they provided you a copy?
Yes.
Okay.
But I also, I'm sorry, Your Honor.
No, go ahead.
I also filed an answer yesterday where we have established a defense of retaliation for conditions and repairs issues.
Whether you've established it or not may be an issue, but I see the answer. Ms. Martin?
You want a response? I'm sure. Your Honor, this is a month-to-month tenancy. A lot of the things in the answer are totally irrelevant. The fact that he allowed a month-to-month tenancy after the lease ended in end of April, she said they waited 7 months. The woman hasn't made a payment since October 3rd. She's always been behind. Late fees weren't charged until November. All those other months she was behind. And this was an inspection deficiency notice. It's an annual inspection. They've had an annual inspection. They've been there multiple years. And now all of a sudden, when we ask for a termination of tenancy on a month-to-month tenancy, they're claiming the place isn't habitable. Move. Either tenant could have given a 30-day notice to the landlord. And this is one where they attempted to do an inspection and the tenant wouldn't allow them access, refused to allow the Section 8 people to come in. And so they were denied access to the unit. And the other thing was to replace a broken window, which it shows on the landlord. I have a copy of this. And the landlord did in fact replace the broken window. We're simply asking for a possession judgment. At this point, we'll waive even any rent, etc. He wants possession of his property.
Your Honor, I dispute the way that the facts have been presented.
Of course you do. That's why I'm here.
The lease ended in April and it continued as month to month. My client's been there for 7 years. And she's had this MISHDA decision pending. And and I have texts. I didn't attach them to my answer because I have a short amount of time to get, an answer to the court. But I have seen texts where the landlord texted my client that her rent as of October 1st was at 0, that she was paid up, but then that's not reflected on the ledger that I was provided. And he was happy for her to continue in the unit without a lease, with a month-to-month tenancy until she made claims that there was mold in the unit and she was worried that it was going to impact her grandchildren. And then 6 days later, a termination of tenancy was filed, and she had made complaints about leaky pipes, leaking dishwasher, leaking sink, and the windows not being sufficient and needed to be replaced within the 2 months before this notice to quit was filed.
Okay, but did she call for an inspection at all?
The inspection, Section 8 attempted to inspect and she wouldn't let him in.
That's not accurate, Your Honor. In December, there was a date that the inspection was supposed to take place and she was in the hospital. Then it was supposed to take place on January 18th. And she went into the hospital that day, but her adult children were at the residence waiting for the inspection. I have text back this up. The landlord called Section 8 and canceled the inspection.
Well, what do you have of proof of that?
That the landlord called and canceled the inspection?
Yeah.
Well, CMA told me that yesterday on my phone conference, so I would subpoena them to testify about how that happened. The inspection is now scheduled for February 1st.
May I speak, Your Honor?
Go ahead. I don't stop anybody. Yeah.
My client is here and he was told he waited for that inspection and was told that they were canceling it. Section 8 was canceling it. And at this point, it doesn't matter if there's another inspection. It's a termination of tenancy. They would not be an occupant and he plans on selling the property. So at this point, it's not relevant if there's some future inspection. This is a termination of tenancy.
I understand it's a future inspection, but if their claim is, but I don't have a whole lot other than words.
May I approach you with a copy of this?
What is that?
This is the inspection deficiency notice by which the issue was to allow.
Is that the same thing that you provided?
No, she's looking at something else. She's looking at the letter that says related to
I would like to
contract.
see that before you present it to the
This is
court.
the same
Okay.
one. I have one. I have multiple copies. Would you like to see this, Your Honor?
What is that?
It's the same one.
Okay, well, hold on. Let's look at it. There are reasons why I shouldn't see it.
I don't have a problem with you seeing it, Your Honor, but I do have an explanation for it.
Okay, of course. Okay, what's the explanation?
Your Honor, Ms. Green has a condition where she's frequently having strokes and seizures and then being hospitalized, and that she has periods of cognitive recovery after this happened. So the issue with the inspection in December is that she was ill. But then, and I strongly.
But I thought that was the one that the landlord canceled.
That was on January 18th. And CMA told me yesterday on the phone with Mishta that the landlord called and canceled that inspection, said that Ms. Green was in the hospital. She was on her way to the hospital, but her adult children, I have texts from her saying my kids have been waiting all day and nobody showed up. And CMA said that they canceled that inspection because the landlord told them that Ms. Green was in the hospital. That's what they told me on the phone yesterday. Because I asked why we didn't conduct the inspection on that day.
Okay.
So my client says that it's Section 8 that called because of the weather. He was available, but on whatever date and there is nothing, he did not cancel it. So my problem, Your Honor, is all of this is not relevant to a termination of tenancy.
I've heard you now for the last 5 times. I get that.
I'm having trouble.
I understand your position. And I guess I'm trying to understand from the defendant's perspective how all of this. So if you're trying to claim that there's some retaliation, right? It seems to me that you would have a long way to go because obviously there's a program violation that terminated the voucher, right? Terminated the assistance.
I don't think it did, Your Honor, because they paid in January. Mishta paid. That's what I'm saying. I think that this is somehow issued in error because Mishta has continued. Mishta.
Yeah, but Mr. will, they're going to operate on a 30-day time frame, right? From my recollection in the past. So almost would expect that the January payment would be made even if the tenant defaulted, so as not to leave the landlord out, because they have to give certain notice to the landlord that they're not paying.
I'm sorry, I didn't cut you off.
No, go ahead.
They gave a 30-day notice and they said that the contract would be terminated effective 12/31.
Do you know anything about that payment?
It was a direct deposit, Your Honor. There was an outstanding balance and it was credited to the outstanding balance, just like any payment would be made to any outstanding balance. I can provide you with a copy of the ledger.
Right, but
The ledger also has a lot of charges that we think are.
We're not asking for a money judgment.
I know you're not. However, I'm going to get to another point. If the notice I have, the notice to terminate tenancy, indicates that she was to move by December 18th of 2023. So whether it be mistress payment or the tenant's payment, let me just strike that for a moment. That's just one question. Does the mischief payment pay the entire rent?
No, Your Honor, and I do have some.
Okay, well, somebody just answer my question. I'll let you guys talk. How much does the tenant owe?
Well, right now, the rent has been calculated for Ms. Green's pay.
Why can't I just get a simple answer? How much is the tenant's portion?
Right now, it's calculated at 962, but it's under review because she lost her income and they haven't reached out to me.
Okay. Let me try it again. In December, what is the tenant's portion?
960.
Okay, so how much was paid by mischief or paid by the voucher?
On January 5th, there was a direct deposit of 704 from the ledger, which did not even cover the prior 2 months.
I hear you. Here's what I'm going to do. If your answer to my question doesn't directly answer my question, all of the other superfluous stuff, I'm not paying attention to. All right. I'm asking questions for a reason. So December paid December, that same amount was paid. January, a certain amount was paid, right? So my question, and accepted by the landlord, right? So my question is, why, given the notice that I have, do I not potentially have a park forest problem more than anything? Wow, silence. I should have
Do
asked.
you want me to answer this, or are you waiting for someone? I understand what you're asking. Any payments, even with the payments, it would go to arrears before it's paid. That's true of any landlord case where you have somebody making payment. You can't come in and say, I'm going to pay February rent and you owe all this money in the back. And this was, a surprise. And there was a huge outstanding balance as of that date.
First of all, Your Honor, we dispute that there's a huge outstanding balance. And to be honest with the court,
Of course you do.
I would need a moment to consult on the park forest or.
Well, there may be a simple answer to it, because what Ms. Barton is indicating is that there's a huge back balance, which means that whatever was paid was not paid beyond the expiration of the notice. But what you're claiming to me is that there were payments that were made. You're disputing their balance, but I don't know to what extent, and I realize rent is not the issue here, but to the I don't know to what extent you're disputing the balance. Go ahead.
Your Honor, I've submitted a reasonable accommodation request that the rent be recalculated back to at least December 1st, because Ms. Green lost her income November 27th. Her daughter had lost her income in October, and the rent should have been recalculated because her disability wasn't able to get a new form that they're requiring.
Okay, but Ms. Bauer, that doesn't answer my question. At some point, let's say it's recalculated and her portion is 0 for December and January. Let's just, for the sake of argument, let's just say that. Prior to that point in time, was there money owed?
Your Honor, if there was any money owed, it was a portion of November's rent, and I say that because Ms. Green had been paying more than she was supposed to. And then she was caught up in October. Also, water bills have been added to the list that she paid directly to the water company. So I think the amount that she actually owed is small once the rent is recalculated.
Okay, but
Not asking for money judgment.
now for the fourth time I've heard you this story. it- But you, Ms. Bauer, can't tell me that the payment the landlord received in December would have paid beyond, or would have paid to the end of December.
I'm sorry, Your Honor, I don't understand your question. The payment that the landlord received from,
Misca, because I don't think he's received any other payments from her.
That's correct. October 3rd was the last payment from her.
Heard you again.
Well,
No, I get it. You're making a record, but I really, I can still hear. I'm old, but not that old. So what I'm asking is this. At some point, you're saying her rent 0, right?
I think that it will be 0 very soon. Because I've done a request for reasonable accommodation, but it's not 0 today. But this isn't a non-payment of rent case, Your Honor.
I apologize, Your Honor.
I know. I get it. But if this were a non-payment of rent case, I wouldn't be bringing up Park Forest because it wouldn't matter. I'm bringing up Park Forest only because you're claiming that she paid or would pay or whatever. I am asking, at what point does the rent 0 out so that I can even get to the beginning of a Park Forest analysis? But nobody seems to be able to answer that for me.
I have a copy of the ledger if you'd like to see it, Your Honor. And then you can see, you can answer that question without them answering it.
I don't think the ledger is accurate.
Okay. Then if the ledger's not. Okay, let's try it this way. December or January, did your client make any payments?
No, Your Honor.
Okay.
I have one more piece of information that I haven't told you yet, Your Honor.
Oh, joy, go ahead.
Mishna did confirm that Ms. Green should be provided with a moving packet. We're supposed to get it today.
Okay, so while I've sat up here for the past 20 minutes, she's moving?
They've approved for that process to start, but she doesn't have the packet yet, and it's a process.
Okay, I get that, but she's moving.
Yes. I mean, yes, Your Honor.
Okay, then it seems to me that the party could sit there and talk to each other about a move out date. Why can't we do that?
I've asked,
I did not feel that plaintiff was flexible about more than 10 days based on previous conversations.
Oh, dear God.
shouldn't ask me.
Okay, yeah, so why don't. Can I put both of you into a room and you guys see if you can work that out?
Gladly, Your Honor.
Okay, so you guys go out, use one of those conference rooms. Alan, keep a watch on the door. Don't let him out. You guys, what?
Can I just say, Your Honor, I am not trying to frustrate the court.
No, I am not frustrated. This is my normal state.
But I'm still learning, and I didn't realize that that was the thing I should have led with, is all I'm.
That you should have led with what?
That she was gonna be given a moving camera. I didn't realize that's what I should have.
Oh, yeah, you should have led with that probably about an hour ago.
I'm learning.
All right.
I'm learning.
Okay, you guys go in there and you guys figure it out.
Thank you. Thank
You're welcome.
Moving back.
Oh, quit threatening me. I am so afraid to call the next case. Court, but I will.
Well, Your Honor, we attempted, and I will say attempted, to reach an agreement. We had reached one, sort of, and Ms. Bauer then called and said no. She's asking for a date with no promise of rent of April.
Your Honor, I do want the court to know that I investigated, and I do believe that we have a park forest defense that I would like to assert in this case. The landlord accepted half payment after the notice to quit expired. So I believe that the case should be dismissed.
Your Honor, there's two options. One, on the park forest, is that money goes towards outstanding balance, and before that was paid, the outstanding balance was $4,432. We have the notice date. If there's an error, the error was part of Mishta, and we'll gladly return the $704 to make this case go forward. Otherwise, my client's looking at 6 months of no payment at all. There was no payment in November, December, January, February. She's marching March.
Okay, so that we're clear, the only reason I raised at all the park forest issue is because I wasn't sure how much the back rent was. That's the first thing. Second thing is, if you recall, it didn't specifically ask what portions or how much of the rent was being paid by Ms. J. If it was 100%, then clearly we might have that issue. I'm not sure, when I was on break thinking about it, that you can raise it certainly, but I'm not sure that park forest would apply because the payment by mistia of that amount, when you look at the cases after that, would have led the tenant to believe that their tenancy was continuing. And I think that would be a hard burden for defendant to put forth on it. The cold-hearted reality is she's moving.
Your Honor, yes, that process is supposed to start, but I reached out to try to get a time frame, and they said it takes approximately 30 to 60 days, more likely closer to the 60 days. And if the court's not thinking of accepting the park forest defense today, I would like time to brief it because I would, I just discovered it.
It's been here forever, but I mean, I wanted to exclude it, but I think given the answers I got, I think that it is excluded because I don't know well, I'm not going to give the whole thing. You guys, go ahead. Yes, I'm sorry.
Prior to her, we had sort of reached a tentative agreement, which my client would agree to, and that is Ms. Bauer keeps saying the money would be forthcoming, they're redoing the money, etc. And we said instead of 10 days, we go 20 days. And if Mishta pays back even in December, January, and February, and then maybe even November, then we could extend the move-out date for another 10 days. That would be 30 days from today. And then that would end, all right? So that at least everything would be cleared by basically, and then even if she didn't move out, you have to have the order, and we're now into March. Now we're talking April and starting all over again, Your Honor. That isn't fair to my client.
Your Honor, I said that I needed to get information about how long moves are taking before we talked about the 20 days, but it's just not sufficient time. And what I said is I'm doing everything that I can to get the cap payment increased to 0% going back to December, but I never said I could guarantee that that was going to happen. I think it's going to happen based on conversations, but I don't have control over that.
Okay, so why wouldn't we just do something like this? If we know it's going to take 30 days for at minimum for something to happen if she's begun that process. Why couldn't we just enter an order that she will vacate in 30 days, but that nothing could issue to force her to vacate without a court hearing? Then at that point, there can be an update as to what the status is, and let the court decide whether or not there would be some additional time granted or not that she would have to go. She may be out in 30 days, which quite frankly is probably going to be quickest in any event. But why wouldn't something like that work?
I think that would be a reasonable path to take.
And I'm not going to, in doing that, I'm not guaranteeing anybody that I'm going to do any particular thing. But if she's close to moving out, then try to get her out. But
And the rent?
Well, I was going to get to that. This part. She had her portion as it stands right now is what,
649 minus 704. The payment for December was 704, and the rent is 1,649.
1,649. So her portion is 16, is 945.
But it's not correct, and I've been addressing it.
Okay, right. But how much, let me ask you this thing. How much do you think her portion should be?
Going back to December, I think it should be 0.
Well, Ms. Bauer, let me just say this. Everybody can't have it their own way, right? I mean, and I get what you're trying to do in terms of the adjustment. But I'm cajoling the landlord to give your client time to do the packet so they can move out. They need some rent.
Well, Your Honor, I basically was told that it will be calculated as of January 1st based on household having no income. And what I'm trying to do is also get the landlord the money from December. When I believe that's the date that it should be recalculated to.
But then, all right, fine. And so if that money comes to the landlord, that's fine because he would be entitled to it anyway. But I'm looking prospectively. I'm saying, if you're going to give 30 days, what does the landlord get out of that? Other than some promise something might happen from CMA and mischief. And I'm sorry, and I don't mean to say it this way, but if I've got to bank on the government doing anything, it probably ain't going to happen.
Well, I can verify with the court that they did say that they had or actually, no, I withdraw that. The household has had no income since November.
All right, Ms. Bauer, why wouldn't I just give them a judgment today? With a 30-day move out, no hearing.
Remember, I think we should be given the opportunity to develop the retaliation defense that we put forward.
This eviction came by assertion of, by her asserting her rights to what?
To have the roof leak fixed and have the mold removed from the living space.
And when did she make that complaint?
November 12th. And I've attached a copy of it to the answer, along with a picture of the moldy ceiling.
And did she report that moldy ceiling to anyone?
In writing, no.
Pardon?
In writing, no. To the best of our knowledge.
Go ahead.
Well,
These are dates that are new to us. In their answer, they mentioned a leak because of the high water bill, that when my client's work people were able to get in, because she has denied access before, there was a toilet running upstairs that nobody corrected. The dishwasher has been replaced 3 times in that property, and he's never charged her for the dishwasher. There are all sorts of issues. She denied access to Section 8 because she didn't think that it was, that housekeeping was sufficient. And you can see from the thing, program was terminated by violation of the tenant. I mean, I don't know. I'm gonna stop.
Well, here's what I'm going to do then. I'm just going to set this for final settlement conference on the 13th. And then at that point, you guys are either going to have an agreement or you're not. And then I'm going to set it for trial. You can develop what you want to develop, Ms. Bauer. I think some of this is problematic in terms of developing, because I don't think that's going to constitute, based at least on what you're telling me now, a retaliatory eviction. Legally, I don't think that it is. I also legally don't believe that there's a park forest defense. But you can bring it all on the 13th, and I can very quickly look at it and probably potentially rule on the issue.
And the time, Your Honor?
Final settlement conference, we in person on February 13th, 2024 at 9 a.m. Great. I get to see you guys the day before Valentine's. You know, and at this juncture, the rent not having changed and her rent being $945, I am going to order escrow in that amount of $945. If it changes, then, and that would have to be paid by the 5th of February. That's the monthly escrow. If it changes to 0, then I'll readjust it. But absent that, that's what I'm going to set escrow at. Okay. Thank you.
Can I just ask, if we do get some written notice from Mishka that they are going to retroactively adjust the rent, can Ms. Green bring that to the court on the date that the escrow is due?
Well, here's the thing. There's a penalty for not paying the escrow. I'm not going to take some piece of paper from whomever about that. I'll deal with that on the 13th if she hasn't complied with escrow, which could involve just a setting of an immediate trial.
And I'm sorry, you said the escrow is due on February 5th?
February 5th.
Thank you.
Thank you, folks.
In this contested eviction proceeding, The court addressed a month-to-month tenancy termination involving a Section 8 housing voucher, focusing on whether the landlord was entitled to a possession judgment and whether the tenant, Ms. Green, had viable defenses based on retaliation, improper notice, payment acceptance, or housing authority errors. The landlord sought possession following termination of the month-to-month tenancy, citing proper notice and a Section 8 contract termination allegedly based on tenant program violations. Defense counsel objected, explaining that a termination notice dated December 1, 2023, had only recently been provided, and argued it was issued in error because no final administrative law judge decision had yet been rendered. Inspections were delayed due to the tenant's repeated hospitalizations, and the housing authority had continued making payments into January. Defense further asserted retaliation, claiming the termination followed tenant complaints about mold, leaking pipes, broken windows, and unsafe conditions affecting her grandchildren, and disputed the landlord's ledger, arguing the tenant had been current or overpaid at certain points and that rent should be recalculated retroactively due to loss of household income and disability-related reasonable accommodation requests. The landlord countered that the tenancy had been month-to-month since April, that the tenant had not made direct payments since October, that late fees had been waived previously, and that inspections failed due to denied access, not landlord fault, emphasizing that the landlord was no longer seeking rent but solely possession in order to sell the property. The court expressed frustration with the lack of clear answers regarding rent balances, voucher payments, and recalculations, repeatedly emphasizing that while money damages were not being sought, payment history mattered only insofar as it might implicate a potential park forest waiver defense based on acceptance of rent after notice expiration. After extensive questioning, the court indicated skepticism that park forest applied, noting that partial voucher payments made by a housing authority under statutory notice requirements do not necessarily create reasonable reliance by a tenant that tenancy continues, particularly where large arrearages allegedly existed. The court also expressed doubt that the facts as presented met the legal threshold for retaliatory eviction, observing that Section 8 termination for program violations undercut the retaliation theory. During discussions, it became clear that Ms. Green had been approved for a housing relocation packet and intended to move, though the process could take 30 to 60 days, prompting the court to push both parties toward a practical resolution. When negotiations failed to produce agreement, the court declined to issue immediate possession but also declined to dismiss the case, instead setting the matter for a final settlement conference with the understanding that absent resolution, the case would proceed swiftly to trial. The court ordered escrow in the amount of $945 per month, reflecting the tenant's current calculated portion, payable by February 5th, with the warning that failure to comply could result in immediate trial, though the amount could be adjusted if officially recalculated by the housing authority. The judge emphasized that while sympathy existed for the tenant's medical and financial circumstances, the court could not rely on anticipated government action or speculative adjustments, and stressed that legal defenses would be evaluated strictly under applicable law at the next hearing. The case was scheduled for an in-person final settlement conference on February 13, 2024, with the court signaling that it would then either enforce possession, allow limited additional time based on verified developments, or proceed directly to trial if no lawful resolution emerged.